Hello and welcome to the latest episode of the Speed Mooting Partners in Crime podcast. My name is John Dove and I'm a co-host of the podcast along with Hayley Crombleholme. And on today's episode, Hayley and I discussed the following. We discussed Section 39A of the Criminal Justice Act, which amends the limitation period in relation to Section 39 offences in a domestic context. We discussed the importance of the particulars of claim in relation to civil litigation. We discussed the latest from the Advocacy Club. We talked about our upcoming Speed Mooting Autumn Cup competition at BPP in September and the fact that all entrants will now be receiving a copy of our exclusive mooting guide. And we also answered a number of your questions. So it was a fun episode. We enjoyed recording the episode and we hope you enjoy. Welcome to the podcast. And welcome to the next episode of the Speed Mooting Partners in Crime podcast. I'm John.
And I'm Hayley.
And welcome along. If this is your first time listening, welcome. If you've listened before,
welcome back.
Hayley and I form the Speed Mooting team. So
the Speed Squad.
The Speed Squad. Our listeners are known affectionately as the Smooters. And if you want to know a bit about our background, I'm a barrister.
And I'm a solicitor.
So we talk about everything that we do here at Speed Mooting. We talk about the law. And we talk about things that are not related at all as well.
We probably talk too much about things that are not related. But we have fun.
We have fun. It's a light-hearted podcast. We've had no complaints so far, so we'll carry on in that vein.
In fact, we've had some positive comments about
we've had some very positive
our tangents.
Yeah, so it looks like people are enjoying the content, so we enjoy recording it, so there's going to be more and more of the same.
Yep.
So we always start with the number for the podcast episode.
It's getting trickier, isn't it, as the numbers get higher?
Yeah, we started with Formula One drivers. Then we veered off into football a little bit.
Yep.
Neither of us are particularly big football fans, are we?
No.
For background information, in case you're curious, Hayley supports Liverpool, I support Everton. But this week is going to be the first week that we venture outside of Formula One and football.
Interesting.
So we're up to episode 12, and we always name the episode after somebody with the corresponding number. Now, there isn't anyone who's number 12 on the current Formula One grid, or, as far as I can see, in the 11 seasons that Formula One have used the current numbering system, there hasn't actually been a number 12.
So what are we going to do?
So, I was thinking football, and then I thought Everton and Liverpool. Can't even really think of anyone famous that, anyone that springs to mind when you think of the number 12. So if we're going to stick with football, the only person that jumps out is Thierry Henry of France. Okay. Now, I asked Alan about this. Alan's my brother. And we were saying, famous sports stars. So we did a quick Google. And the first one that came up was pretty obvious, a pretty big sports name. So I think he's going to get the accolade for this week's episode.
Who is it?
Tom Brady. He's an American footballer. So when I say football, the kind of funny shaped thing that they throw around.
Like Hey Arnold's head.
Hey Arnold's head. Yeah, it doesn't really involve any kicking at all, but football nonetheless. But this guy's pretty good. I don't know much about American football. I've watched the Super Bowl occasionally, but people talk about him. He's kind of the Michael Schumacher of American football,
Wow, okay.
So he's kind of the big name.
Who's the swimmer
Michael
called?
Phelps.
No, there was Tom something. He was in the Olympics, wasn't there?
Tom Daly.
Oh, that's who I was thinking of.
He was a diver, not a swimmer, wasn't he?
Oh, well, he does something that involves water.
He goes in a pool, doesn't he? So, practically, I suppose he's got to swim out the water once he dives in, so... That's this, Tom Brady. He's a big name in American football. Won a number of Super Bowl rings. Whether he's won the most, I don't know. Wouldn't surprise me if he has. So there's him. But also, not linked to the number 12, but came up this week. Kevin Campbell, very legendary Everton player, sadly passed away this week.
Right.
So we'll give him an honorary mention as well. So this week is the Tom Brady, Thierry Henry and Kevin Campbell special.
Welcome.
Welcome to the podcast. We're going to start with the legal corner this week, Hayley.
Okay.
We've been shaking things around. Sometimes we deal with that later in the episode. I think let's start with the law. We'll start with crime. And for those of you who are new, we like to talk about, things that might pop up as part of our practice or things that we think are relevant. Now, I tend to spend most of my time these days in the Crown Court, or when I do go into the Magistrates Court, it's because I'm dealing with motoring cases. So it's very, very rare that I find myself in the Magistrates Court dealing with sort of a general criminal case.
Mm-hmm.
And I did find myself in the Magistrates Court dealing with a general criminal case recently. And as part of this case, the CPS needed to lay an additional assault by beating, so Section 39 assault by beating charge. Now, for those of you that don't know, summary-only offences have a statutory time limit of 6 months. There are some exceptions for certain offences, but as a general rule, a summary-only offence has to be laid within 6 months of the date of the offence. Now, I remember looking at this when the CPS laid the charge, and I was thinking to myself, this looks like it's outside of the 6 month time period.
Ooh.
But I had to remind myself of Section 39A of the Criminal Justice Act. Now, I did know about this previously. It's just because I don't have a particularly prominent general criminal magistrates court practice at this moment in time. I had to remind myself of this, because this came into force a couple of years ago whilst I was at the CPS, and I dealt with a lot of sort of domestic abuse cases. So Section 39A was quite prominent in my practice.
Okay.
Effectively what this does is this gives an extended limitation period in relation to common assaults or assaults by beating in a domestic context.
Right.
So what Section 39A does is that extends the limitation period in relation to a common assault or an assault by beating in a domestic context. So your 6 month time limit is then extended to 2 years, but the condition is that the complainant must either provide a witness statement or be interviewed by the police within 6 months. So effectively, you've got 6 months from the date of the statement or the interview by the police to lay the charge.
Okay.
So I had to remind myself of that, but it's just something interesting to know, and particularly for those interested in criminal law, it's just one of those nuanced points which is important, particularly for criminal litigation.
There we go. Interesting.
Yeah, very, very interesting point. So, Hayley, you like to talk about civil litigation as well, don't you?
Yeah, shake it up a bit.
Yeah. Now, I remember a little bit about civil litigation from my years as a paralegal in civil litigation, no less. The beginning of a civil case is, the beginning of the litigated case, once you're past your pre-action protocols, is the service of the claim form and the particulars of claim.
Yep.
So, Hayley, do you want to talk to us about what the particulars of claim is and why that is important?
Yeah, sure. So, firstly, I'll just go back because you mentioned pre-action protocols there. So, for people that are complete novices to civil litigation, when we talk about pre-action, as you can probably guess, that just means the steps that have to be taken before you can issue a claim. So things like you have to send a letter before a claim to a potential defendant. You have to give them a chance to settle before you issue a claim. There's all different pre-action protocols depending on what claim you bring. So, for example, there's a general pre-action protocol, stuff like dilapidations, which is a fancy word for building disrepair, essentially, has its own protocol. So when we talk about pre-action, we basically are referring to all your ducks being in a row to commence a claim. So your question, John, was about the claim form and the particulars of claim.
Yeah.
So essentially, in a nutshell, very simply put, this is the document that you send to court and the defendant when you commence your claim. So it has to set out, claim form has to set out who the claimant is, who the defendant is, a very, very brief summary of what the claim is. Is it a contractual claim? Is it a claim under a lease? Is it a claim under a hire purchase agreement, etc.? And if it's a monetary claim, how much you're claiming for.
Right.
So the claim form itself is fairly simple, concise, to the point. The particulars of claim is a lot more in depth. hence the word particulars. So that is usually, I mean, depending on what it is. So I was in property litigation most recently, so they would be very heavily drafted documents, usually setting out multiple clauses in a lease, in a mortgage, etc.
Yeah.
So it's all of the details to prove to court why you have the right to bring a claim, what the defendant has done, what recourse you're seeking, and what area of law, how you're entitled to that, whether it's a contractual right, some right in statutes, etc.
Yeah.
Now, a very commonplace for us, for solicitors, if it is complex, and in most cases it is when you work in commercial firms, we get barristers to draft our particulars of claim a lot of the time. Barristers generally are very good at drafting. They do a lot of it, and quite often than not, it's cheaper to get a barrister to draft the particulars.
I can imagine.
So in your time as a paralegal, did you used to get barristers to draft your particulars of claims as well?
Yeah, it all depended. So
I think in when you work in volume type work, so when I worked as a paralegal in mortgage repossession a long time ago, that was volume based work. So every claim was essentially the same, other than changing names and how much they owed on the mortgage. So that type of stuff is not so common. But when you do you look like you're about to interrupt me.
No, funny you should say that. So when I was doing the volume stuff, so because for a very brief time I did sort of road traffic accidents, and that was volume based, and all of that used to go off to council. But
it went to council still?
That went to council, but I think it's partly because of the way in which costs worked back then. So that was all prior to last spoke being the Legal Aid, Sentencing and Punishment of Offenders Act 2012, which had massive implications in relation to cost recovery and civil litigation. But prior to that, when fixed fees were in place, the cost of counsel to draft particulars, even on very basic road traffic cases, were recoverable. And it made sense because quite often counsel would be asked to draft an opinion at the same time, for example, in relation to quantum, and they would likely be dealing with a disposal hearing at the end of the case. So it made sense on that volume work. But the bulk of my time in civil litigation was spent on still volume work, but not quite the same volume as road traffic. And it really just depended on the nature of the case. So if it was quite a complex case, we would send it off to counsel for the particulars of claim. Simpler cases we tend to keep in-house, and I think part of the reason for that was because of the I think it was the cost implications in relation to that. So I did spend some time drafting particulars of claim, and it's interesting that you say there, about the way in which you draft them. So obviously a lot of the employers' liability cases I dealt with would have certain regulations, so we'd have to cite those within the particulars of claim, but you'd also say further or in the alternative, we're pleading general negligence, and set out the particulars of general negligence.
There usually is a paragraph towards the end of your particulars, and the claimant claims this in the alternative, in the alternative, in the alternative, in the alternative. Just, don't put all your eggs in one basket. So, but yeah, whenever I could, I used to enjoy drafting particulars of claim, but when I got more and more advanced, and was dealing with a lot more complex stuff, it made sense more often than not to get counsel to do it for us.
Yeah.
But yeah, it's one of the most important things you do actually when you do commence a claim, because obviously it underpins your entire case. There is exceptions, if you make a mistake on the particulars or in your claim form, they can be amended, but it's just a nightmare. You don't want to do that unless you have to.
Do you have to say an application to amend?
It's usually an application to amend, an application for permission to amend the statements of case, etc.
Yeah. And then all the amendments stay on, don't they? So you have sort of red lines going through, and if it's amended twice, you've then got a green line.
If you can get something amended under the slip rule, I've done that a few times, again back when I was doing mortgage repossession, because we used to use the same stuff. Occasionally, if it's a very simple typographical error, for example, you used to just get a ruler, a red pen, draw a line under it, draw the red pen, send it to court, and they'll stamp under the slip rule and it's amended.
Okay, right.
But yeah, you can see the amend stay on there, the red pen stays on there, very, very interesting. But yeah, essentially when it comes to the next stage, which we won't go into, we can probably say at the front of the time, someone defending the claim, they're essentially, taking your claim form and your particulars of claim to pieces. So you want that to be as nailed on as possible. Yeah. No one likes to get a defence back and it says paragraph 12, this does not make sense. See paragraph above, this conflicts. Like, no, you want a really, really solid particulars of claim. So it's one of the most important things, to get right at the onset.
Yeah. You get some snotty people, don't you, that say, I'm embarrassed by the pleading of paragraph 8.
Yes. Yeah. We've talked about that before, haven't we? In litigation in particular, opponents, and in some ways it's a bit of a show for the client, I think, the stakes are really high for them, the emotions are really high for them, so they like to see their barristers and their solicitors having a bit of a battle. Yeah. So you can't be too polite in your correspondence when litigation's involved. They like to see that it's, it's robust, it has some teeth. But the reality is when you speak to opponents on the phone, it's usually, especially if it's without prejudice, really friendly, really professional chats and everyone gets on together. Yeah. I've had some and we've been in settlement negotiations back and forth for years and we're like, we're nearly there, aren't we? Oh, yes. I hope this is the day. I hope this is the day too. Let's see if we can get this settled today. Because at the end of the day, the court process, it's so long-winded and it's so expensive and the court resource is so precious. We always want to settle. Like, no one wants to get to trial. No. So settlement's always the best option. And if we can settle before we even issue a claim, then that's brilliant. That's a great outcome achieved.
Oh, definitely. That's the big shocker for me. The way in commercial law, every piece of correspondence is approved by the client. Am I right in thinking that every email you send to your opponent is approved by the client?
Yeah, for the most part. I mean, it's not so much approved because they trust you to do the work, but we would always seek instructions before we send something, especially if it's, settlement negotiations, etc. I mean, we might have, if we have a conference with the client and, we've got their explicit instructions to try and get this outcome, to put this across, and there's back and forth instantly with the other side, you probably in that instance wouldn't go back to your client every single time and go, they've said this, can I say this? They've said this, can I say this? But generally you would. And any letter, 100%, I would always show that to my clients first. I mean, you learn the nuances of your clients. So some clients really do like to go through it with a fine-tooth comb and send you back comments. Others are like, you're my solicitor. Why are you asking me to approve? So it's not, you have to be careful with those ones. It's not, can you check this? Can you approve this? This is what I'm going to send.
It's like having a joiner going, so do you mind if I put this screw in here?
Yes. But also, as I say, some clients really do like that. And it's also to protect yourself, if you say something that's not 100% true, but you've got, you sent it to your client and they checked it, that can help. But yeah, a lot of the clients, it's strange, but I find it's, the more senior clients, so like the CEOs and stuff, they'd be more often than not the ones who be like, why are you asking me to approve this? So
too busy.
Yeah, it has to be, this is what I'm sending, just letting you know, or this is what I'm going to do. I'm doing this now. Yeah. Just looping you in, rather than, can you check this? Yeah. They don't always like that, and you can understand it, but some of them really, really do. So it all depends on the client.
No, definitely. I mean, when I was a criminal solicitor, obviously everything that we're doing is on the basis of our client's instructions, but you just couldn't imagine going back to the client, right, I'm going to chase the CPS here for a
no,
for the disclosure that should be sent. Can you prove this email?
Yeah. And I think it depends on what type of cases it is as well. Like, when I was doing mortgage repossession stuff, obviously we were working for banks, huge commercial clients, don't get much bigger than that. But you'd have a portfolio of, I don't know, I used to have about 300, 400 cases live at a time. Unless you were asking them to make a big decision, you had their mandate, you know what you can do. You wouldn't go back to the bank every day and go, can I send this letter? Yeah, can I send this? But when it's, a multi-million-pound dilapidations claim, bet your bottom dollar every single letter you send is going to your client first. And 100% going back to the, the claim form and the particulars of claim, that's all underpinned by a statement of truth, so that would never go without instructions.
Well, of course, yeah. And likewise, there's certain things, for example, in crime, a defence statement that's always going to be signed.
Yes.
Base of play, you'd always sort of have that approved before you were pinging that across or anything. But yeah, general correspondence.
No. There we go.
Yeah, there we are.
Little insight into litigation.
Yeah, the differences there. So, Hayley, we get some questions in sometimes, don't we?
Yeah, we do.
So, before we jump onto our questions, listeners, if you're a first timer, you may not have heard me say this before. Feel free to ping your questions into us. You can send them to our email address, info@speedmooting.com, or if you want to put your question on social media, use the hashtag
#SpeedSquad. But also put it on our post so we can find it.
Yeah. Try and tag us as well, We do check the hashtag, but obviously tag us as well. We'd appreciate that.
Yeah, definitely.
But yeah, no, of course, we've got some questions, haven't we, Hayley? So
we have.
I think the first one was for yourself. I think it was civil-based.
Okay. Hi, Hayley. I see you've had years worth of experience in real estate disputes. This is an area of law I'm interested in, and I was wondering, how did you find it? What did you like about it or not like about it? Interesting. So, for those who don't know, I talk interchangeably about real estate disputes, property litigation. They're all essentially one and the same thing. So we're talking about contentious disputes about land or property, essentially. So how did I find it? Firstly, as I say, I was a paralegal in mortgage repossession for a long time, then general debt recovery for a good while. I ended up dabbling in compliance for a few years while I waited to start my training contract, and then my seats as a trainee, where I started with commercial litigation because I came from a litigation background, so I assumed that would be the area that I would want to qualify into. So I got that preference first seat, which was great.
Yeah. Then
I did... commercial litigation was split with banking and finance. So it was a split seat.
The fun stuff.
It was a very, very bizarre split, as you can imagine.
Yeah.
But happily for me, it ended up being 80% commercial litigation, and basically whenever the banking partner had a big deal to complete, he'd pull me in to file things and be there at the completion meetings. No offence to any banking and finance lawyers out there, but it didn't really float my boat. So commercial litigation, I thought this will be the one I wanted to qualify into, and I did enjoy it a lot. However, there's no real way for me to say this other than it felt really random. Like, every case was so random. Like, one would be a dispute about a car, and then the next one would be a shareholders dispute, and then the next one, it's just, there was nothing that underpinned anything. Yeah. So apart from civil procedure rules, which was a kind of a constant, there was no pattern, there was no law or anything that underpinned all this stuff. It was just random disputes about everything. So I was thinking, gosh, how long does it take to build up like a specialism in this area? And it all felt very random. So I didn't love it. I enjoyed it a lot, but not so much that I was like, I don't know if I could see myself here forever. So then I went to real estate transactional, which we've talked about this on the podcast before. Yeah. Thought I was going to hate it, actually really loved it. Really, really loved property, but I just knew I wasn't a transactional lawyer either.
No.
Always done litigation, really loved it. I enjoyed the pressure of court deadlines, and it's nice to win.
Yeah. Well, that's it. It's a battle, isn't it?
It is a battle. Yeah, it is a battle, and it can be really fun.
Going back to what you were saying, having a good settlement can be sort of a win in and of itself.
100%. Like, definitely get thrills over the settlement because they happen so much more often, and it's best for everyone. We're doing what the court wants us to do, so that's always a great outcome. I loved real estate, but I knew deep down I wasn't going to be a transactional lawyer. And there was one, he was an associate at the time that worked in the real estate disputes team. So I think he was really from the Sheffield office, but he was working in Manchester a few days as well. So I was kind of like, mooching over to him, seeing what type of work he was doing. And at the time, real estate disputes wasn't a seat in my office, in the Manchester office. Right. So I asked, and they were like, oh no, we can't have a seat in that department. But then I went to the general property, like, Christmas party, and there was like, this is the real estate disputes partner. So I was like, after a few wines, basically just talked his ear off about how much I wanted to do a real estate dispute seat. And then I kept on at the associate in the office about it as well. And we made it happen. They made a seat in the Manchester office for me. So that was still litigation, but it was all underpinned by property. And there's so much law in property.
Oh, tell me about it, yeah.
As anyone that studied land law, equity and trust, etc. will know, there's so much law. And bizarrely, I really, really like law. So, yeah, within 2 months of being in that seat, I knew I wanted to qualify in real estate disputes. And I did, and I didn't look back. So that's how I found it. And yeah, I think I've pretty much already described why I loved it. What I didn't like about it, that's a tricky one. Probably what I would say is, compared to general litigation, I think, or was my experience anyway, property litigation is there's a heavy focus on advisory work. So you'd be surprised, but not many cases are litigated, and not many cases, even less, make it to trial. I could count the trials I had on one hand, maybe. The big ones.
Yeah, of course.
With the exception of, possession claims and trespass claims, etc. They can go through the courts very, very quickly, evictions, that type of thing. But the larger cases and the majority of the work you do for the high-end commercial clients is just advisory stuff. And, that's partly because we're so good at what we do. We help them resolve the disputes before they even need to issue a claim form. But I think that did surprise me. It's not completely full of court processes, quite the opposite.
You're looking at ways you can avoid trials if possible, avoid litigation.
And it could be, I'd be interested to know this actually. It could just be because when I was in general litigation, that was so many years ago, maybe that's the way litigation is more generally now. Maybe even commercial dispute resolutions aren't dealing with court day in, day out.
Yeah, it looks that way. I mean, I don't know a great deal about it because obviously I've been out of that world for a long time, but you do see a lot of things popping up these days about people being encouraged to go to arbitration and things of that nature. You see things like that popping up, so maybe that is the general sort of direction it's going.
Maybe, yeah. So I wouldn't say that wasn't something that I disliked about it, but it was something that surprised me. A lot of it is advisory work.
Yeah. Well, really interesting.
I think that answers that question.
Yeah, great question.
So one question we've had in, obviously we talk about mooting and advocacy an awful lot. It's what we do here at Speed.
Surprising that, isn't it?
It is surprising, yeah. Speed mooting, talk about mooting.
Who'd have thought it?
Who'd have thought it? But anyway, so we obviously, what we do is very, very relevant to aspiring barristers. But we also have a lot of solicitors and aspiring solicitors with us as well. So the question we got is learning how to moot relevant for an aspiring solicitor?
Okay, interesting question. The short answer, I would say, is yes. So I'll break it down like this. The first one is that some people who want to be solicitors want to be solicitor advocates. So naturally you can see why there is a need for somebody in that position who wants to be a solicitor advocate, or even a solicitor without higher rights of audience, but conducting advocacy that's open to solicitors anyway. So magistrates court advocacy, civil advocacy, up to and including fast track trials. You can see why there's a natural importance there to learn advocacy. So that's the obvious answer for those who have an interest in advocacy. I would imagine where this question is going, and maybe the thinking behind the question, is for someone who's never going to practice in advocacy and is going to be a solicitor, whether that's litigation, non-litigation, etc., does that individual need to practice mooting? And once again, I would still encourage you to practice mooting. Firstly, think about the skills that go that you need before you even get into the moot room. So if it's a traditional moot, unlike ours, where research and drafting is required, we need to think carefully about how you're going to formulate your argument. Where does the research start? So going on to Westlaw, going on to Lexis, searching for the cases that are relevant to your argument. You're looking at, if the argument's against you, looking at ways you can distinguish those arguments and looking at ways you can effectively overcome the law that's against you. So you're really buttressing your research skills there.
Yeah.
Once you've got that, you've then got to put that down onto paper. So you need to draft a skeleton argument. And that's quite a skill in and of itself, because you need to formulate a way that you can put your argument onto a few pieces of paper in its bare bones form, not obviously go over the top, not turn it into a speech, and put that down. And that's relevant because solicitors do, as you can probably attest, Hayley, an awful lot of drafting.
Yep.
And I think being concise is really important, because verbosity isn't helpful for you because it's time consuming, not helpful for the reader because if you're trying to give legal advice to your client, you need to give it in a way that's effectively user friendly, in a way that they can follow what's being said. It needs to be concise. So drafting is absolutely crucial. And if you draft well in terms of a skeleton argument, don't forget that your judges see that in advance, and that's a way for you to be persuasive to the judge before you even go into the moot room. Stand up and address the judge. And that's relevant for real life, because whenever you go to the Court of Appeal, you'll submit a skeleton argument beforehand, and if you've been persuasive on paper, the judge sees your argument and they're sort of on all fours with you already. That helps you when you go in and you're going to deliver your oral arguments. So you're building up two really good skills there in terms of your drafting and your research.
Yeah.
But it's also going to help you in terms of your study as well. Because when it comes to sort of problem questions, or even the sort of analytical type questions that you might get as part of an exam, well, you've been able to think critically. Because coming back to what I was saying about the research, you're thinking about the law, or how the law is going to apply to your argument from two sides. A, how the law is going to support you, but B, how you can look at the law that your opponent's going to cite and how you can knock that down, how you could distinguish the facts of the case, how you can say that the case law doesn't apply, or find better case law than that which your opponent will cite.
Yeah.
So you're developing your critical thinking skills there, which will, of course, help you when it comes to exams, but of course help you when it comes to practice as well, and when you're coming to apply the law. So I think that mooting is a really crucial skill. And it's important for everybody to try, whether you're interested ultimately in advocacy or not.
Yeah, definitely. I mean, I can't think of any type of practice where analytical skills, research skills, drafting skills aren't needed. Yeah. Litigation is an obvious one because, it's contentious based. You need to be able to go back and forth with opponents and, solve problems for your clients. Even transactional ones, though. Transactional
work, you think about it. Even let's take, for example, let's say you're a conveyancing solicitor. So that doesn't involve any litigation. I imagine doesn't involve any advocacy. But once again, those skills are really important because you need sort of that critical eye. Because I imagine you spend a lot of time reviewing documents, sometimes very historic documents. If you're selling a property that's not been sold for many, many decades, sometimes there might be sort of tricky points that arise in relation to, and I'm just thinking about things that you've mentioned in the past, tree preservation orders or whatever it might be. So you still need to research the law there, look into that and apply that in those circumstances. Drafting is absolutely crucial as a conveyancer.
Yes.
So, I was thinking of an example there off the top of my head, which naturally isn't contentious, naturally doesn't lend itself to litigation. But of course, those same skills that you'd be picking up in mooting can be applied there.
Yeah. And I mean, transactional real estate, when I was a trainee in that department, and it might not be contentious in the sense that, there's court proceedings, but believe me, things can get very, very heated when you're going back and forth over a 200-page lease. Yeah. And sometimes, there's one side wants something in there, one side really doesn't, and you go back and forth for months and months, and, that's a problem. You've got to think analytically about how do you get around that. Sometimes you have to go do researching on this particular clause and, how's it gone wrong, how's it been interpreted, etc. So all of these skills that you can build in mooting will be really, really valuable to you as a solicitor.
Oh, definitely.
And also, it just enhances your CV as well when you're applying for training contracts. If it is the solicitor route you want to go down, they can see that, you know, you've been mooting. That just shows that you're a rounded person. You've tried something else outside of studies. That just shows you've got a genuine interest in the law.
Yeah, and also, if ever you get someone trying to be a bit funny with you in an interview, so why is it that you don't want to be a barrister? You know, normally the answer's pretty obvious. Well, you know, you're interested in the solicitor route, but you can actually come out and say, well, I've tried advocacy. It wasn't for me.
Yeah.
I prefer, you know, whatever aspect of being a solicitor it might be, whether it's contentious or non-contentious. But if you do get anyone trying to be a bit clever with you in an interview and asking that question, you've got an answer straight off the bat. I've tried the skills of a barrister. I didn't enjoy it. I prefer litigation work. I prefer whatever it might be. So,
there we go. I think there are questions answered.
Hopefully that answer was helpful. So we're recording this on Tuesday.
Yes.
Hopefully the episode should go out this Friday. We always release on a Friday, except for last week we had a technical glitch with Hayley. So apologies to our listeners that had to wait until Saturday night for the episode. But hopefully you weren't doing anything more exciting on a Saturday night anyway. So fingers crossed it filled your Saturday nights. But all being well, we should be back out with you this Friday. But nevertheless, it's now Tuesday when we're recording this.
Yep.
Tuesday is Advocacy Club night.
Certainly is.
It is on the penultimate and the final Tuesday of the month.
Yep.
So given that this is the penultimate Tuesday of the month, it is our debating session tonight. Always a fun one, the debating session. I think I say that about everything. It's always a fun session.
This is a really fun one.
It's always a fun one.
But we love them all, so.
But yeah, they're all great sessions. They really are. You know, it's great just to see how enthusiastic everyone is that comes along, and you know, people willing to try, and also people observing, because people coming along and observing learn so much as well.
Yes.
And then, you know, we see a number of people who might observe for a couple of months and then they try it themselves, and you know, they're probably so far ahead of where they would have been otherwise, simply because of the observing and how much they've learned through osmosis, basically.
Yeah, that's so valuable. And people ask us this all the time. We had an email just today from somebody. I really want to join Advocacy Club, but I'm really nervous. Can I just observe? And
absolutely.
I told them, you know, our members, some members that have been with us for a year might choose to observe. That's fine. Yeah. You know, it's all about being fun and low pressured. We would never put pressure on anybody to force them to take part.
Not at all. That's the idea of the club. It's low pressure. You know, it's a chance for you to practice your advocacy, make your mistakes, because you know you don't want mistakes in the real world. So come here, make the mistakes, get somebody to say, "Oh well, you've made that mistake. You shouldn't have done that. What would have been better would have been." Fine, it's no skin off your nose, because you've made the mistake in front of a few other people. No one's judging you, no one's laughing. They're saying, well, do you know what? Here's a way you could have improved.
Yeah.
So that when you come and do your advocacy for real, whether it's in court, whether it's a moot, whether it's a speech, a presentation, whatever, you've ironed those kinks out at the Advocacy Club.
Yeah. So speaking of debating, we shared a nice tip on debating today. Should we share it with our podcast audience?
Let's share it with our podcast audience, Hayley.
Okay, so this is the tip. Are you ready, John?
I'm ready. Strapped in.
So instead of spending too much time criticising your opponent's views, concentrate on developing a well-reasoned and well-supported argument that showcases your understanding of the topic. This approach will not only help you present a more effective and convincing case, but it will also demonstrate your critical thinking and analytical skills to the audience.
Yeah, absolutely. Because, you know, ultimately that's what you're trying to do. You're trying to be persuasive, and you're trying to persuade whoever the debating judge is. Oh, we don't have judges at the Advocacy Club, but let's say you were in a real debate. You're trying to persuade whomever your audience is that your side is correct. And just say, oh, well, the other side's wrong because X, Y, Z. That's going to get you nowhere. So ultimately, what you need to do is you need to present the strengths in your argument. Now, we're not, just to qualify that, we're not saying by any stretch of the imagination, don't knock down your opponent's argument. Because, of course, you know, you will need to do that. You know, if they've raised a point, particularly if it sounds quite credible, if you've got a way of underpinning that and saying, well, my opponent is not quite right because fine. Tell us why you're right.
That's it. I mean, funny little segment. So we don't go political on this podcast at all.
No, we are very apolitical.
We are, but I'll just give a shout out to some debates that have been going on TV recently. You may
some debates,
not over anything massively important, but we watched a couple, haven't we? And I said to you at the end, not one of them is telling us what they're going to do. All they care about is what he says is rubbish. What he says is rubbish. Well, it might be, but what are you going to do?
Yeah.
So you think said people, who shall not be named, will be a bit better at debates.
You would think so, wouldn't you?
But I think they've all been pretty lousy.
Yeah, I agree with you, because the debates have literally just been, this guy's wrong, this woman's wrong. No.
We need to get this tip.
We really do.
Some of these politicians.
I think we do. I think we need to get these people in the advocacy club. We'll train them up, and away we go from there. But just to qualify, we are apolitical. We're not supporting anyone. We're not criticising anyone in particular. We're not supporting anyone in particular.
No, it's a general piece of feedback.
It's a piece of feedback, because every single person we've watched has done this. It's not been...
They're too concerned about their opponent and not concerned enough about their own argument.
Yeah, exactly. And shouting over each other.
Yes. Yeah. Not good.
Not good.
Anyway.
Yeah.
Move on.
Let's move on. So, tomorrow, we are running a mooting course, aren't we, Hayley?
We certainly are. I think, as well, this has been our most popular free online event so far.
It has.
We've got a lot of questions, a lot of attendees.
A lot of attendees. Yeah, we have to have a very upgraded Zoom package to make sure everyone can come on. So I'm looking forward to it, though. It's great to see that there's so many people in attendance and so many people looking to learn. So I'll be sort of hosting this session, won't I, Hayley?
Mm-hmm.
And I'll be spending the first half giving a talk about mooting. So explain what mooting is, why it's important, how to prepare for a moot, and then how to actually perform in the moot itself. So hopefully all of that will be helpful. And then following on from that, I'll open the floor to questions. So we've had some pre-prepared questions.
We've got an awful lot for you, John. An awful lot. We may have to do mooting course part 1 to 10 to get through all of the questions.
I think so.
If you've not signed up for it for whatever reason you can't attend tomorrow, we will record, at the very least, your talk, won't we, John?
Yeah. Oh, yeah.
But if you're really, really keen to see that as soon as possible, then join our mailing list if you're not already. speedmooting.com/contact.
Yeah, definitely. Get yourself on there. We're hoping to have this out to you as soon as possible after the event, but we've got a lot of videos to edit at the moment, haven't we, Hayley?
Yeah.
Or should I say you've got videos to edit at the moment?
We've got a lot of content coming for you guys.
Yeah, so much content. So keep an eye on the Spotify and on the YouTube channel as well, because there's so much coming over the next few weeks.
Content, competitions, events.
Yeah, we still haven't released the video from the most recent competition, have we?
No, it's on the list.
It's on the list. It's coming soon.
We've also had a good few conversations with councils episodes recorded, haven't we? So we'll be releasing those.
3 or 4
recorded.
episodes ready to go. Mm-hmm. Yeah, and it's a good variety because we've got a barrister, we've got a trainee solicitor, we've got a recent National Speed Mooting Competition winner.
Yes.
So lots of great content there, and we've got a few more booked in over the next few weeks as well. So yeah, there's going to be loads of great episodes of conversations with council. Speaking of mooting, I think we mentioned it last week, but we've got our upcoming competition in September, haven't we?
We have.
Places are filling very, very, very quickly.
It's always a popular one, London, isn't it?
Always a popular one. We were shocked because we did our first ever competition in London last year, didn't we? We'd always, even though they're national competitions, we've always centred them in the Northwest, and we still got people from all over the country, all over the British Isles travelling. But yeah, the London one, I think it's the capital, isn't it? Well, I know it's the capital. What I meant to say was, I know it's the capital of the country, and I think that's the reason why it's so popular. So that one filled up really quickly last year. Places are filling quite quickly for this one.
Yeah.
There's only 128 places for this competition by comparison to our online one, which had significantly more.
Yeah, unlike our online ones, we are limited with this one in numbers. So once places have gone, they have gone, unfortunately.
Yeah.
And a point to mention as well, which we released on our social medias today, everybody that signs up will get a free mooting guide from us. So that should be really helpful when you're preparing for the competition.
Yeah, that's a really helpful document as well, because it sets out, similarly to what I was talking about on the mooting course, good information there about how to prepare for a moot, how to present your submission. So hopefully that should help.
Yeah.
Because a number of those that enter our competitions, a good number actually, are first timers. Never done any advocacy or public speaking. So hopefully our mooting guide is helpful to you. Yeah, I think that brings us towards the end of another episode, Hayley.
The end of episode 12.
The end of episode 12. Yeah.
Time is passing. Well, you wouldn't be able to tell because you've just shaved your beard, so...
Yeah, I like him going backwards in time.
Yeah, that knocks about 10 years off you when you shave the beard.
We had someone comment on TikTok saying I look like Louis Theroux. Well, we've got to the end of an episode and we've had no references to Formula 1 drivers or WWE, have we, Hayley?
Or Harry Potter.
Although
it did kind of say who must not be named earlier when I was talking about politicians, so subtle reference there.
Yeah, subtle reference there. But no, I think that brings us to the end, doesn't it, Hayley?
I think so.
It's been another fun one. I've enjoyed it. Have you enjoyed it, Hayley?
I have enjoyed it, John.
We hope you've enjoyed it too. If you haven't already, I know most of you have, but if you haven't, feel free to click the subscribe or the follow button. And until next time,
bye.